Okay. Okay, we are live. Please, Sanna.
Hi all, and welcome to this panel session on COVID and copyright. And we have a really great lineup of speakers. It's Professor Alessandro Enrico Cogo from Italy. It's barrister and solicitor Brian Gray from Canada, and attorney Nathan Yang from China. And I'm really looking forward, because now in this pandemic time, it's a really challenge for copyright, where we are heading and what will happen with copyright, since we have gone so much online in a new ways that we can't really foresee where we actually are heading. And but before we start with the presentation, I have some orders issue too. So, and the order issues are, if you have any questions, then use the Q&A box, and you can see it in the chat where it's, you see the mark, beside the chat you see the marked with a red ring. For technical problems, then you can use the chat. The chat will be covered by IPPI, and I will only look at the Q&A boxes. So if you have any questions to the speakers, then use the Q&A. And please also do the survey afterwards. And the structure of the panel sessions. First, we'll talk about copyright and the exceptions and limitations, because we have very different system in Europe and Canada, US and China, but still the ground is the same, since we are all part of the Berne Convention and the Berne Union. So the detail, the structure as such is the same, but the details on how we use exception and limitations actually differs a bit. So we talk first about exception and limitations and how they have been affected of the COVID. And then we will have questions after that. It will be 10 minutes presentation for each country, and then 20 minutes discussion and questions. And after that, we'll go to the next part, and that will be about the user-generated contents that also have exploded now. So we will start first with exception and limitations in the European Union. And the first speaker will be Alessandro, who will talk from a European Union perspective. Welcome, Alessandro.
Thank you, Sanna. Can you hear me?
Yes, we can.
Yes. Okay, thank you. So welcome, everybody. We have a very limited time for our presentations, so I will go through it briefly, but I trust you will have time for questions afterwards, so we can look deeper into details if you wish to do so. Next slide, please. The question that was posed to us by Sanna basically was whether the pandemic would prompt any kind of modification in the way we apply exceptions and limitations in our legal systems. So to answer such a question, I thought it would be necessary to look briefly into the principles that we have been applying in the past years. So looking at the European Union law and looking at the legislative framework, the following points need to be stressed. In the EU, we have a closed list of exceptions and limitations. First point. Second point is that there's no complementary open-ended clause under European Union legislation. Then, many exceptions and limitations are optional. So the member states are free to implement any of such exceptions and limitations, but also they are free to determine up to a certain extent the content of the specific exception limitation they implement in their laws. Some exceptions and limitations are mandatory. very limited number of exceptions and limitations are mandatory, although the number of exception limitations that the member states have to apply under European Union law is growing, as I'll show maybe in the following. Then, last point is that many exceptions and limitations have not been fully harmonized. As I already said, the member states enjoy a considerable amount of freedom while implementing the exceptions and limitations allowed by the European Union law. Next slide, please. What about the interpretation of these exceptions and limitations by the Court of Justice of the European Union? Here again, I will make a few statements without any possibility to explain why they are consistent with the jurisprudence of the Court of Justice. First point, also from a timeline point of view, is that exceptions and limitations, according to the Court of Justice view, do derogate from exclusive rights and are therefore subject to strict interpretation. This was one of maybe the first principles that the Court of Justice affirmed in connection with exceptions and limitations while dealing with private copying exceptions, basically. A few months later, years later, the Court of Justice added that the exceptions and limitations have to be applied in such a way as to make them effective as they are users' rights. So strict interpretation, right, but not so strict, not so narrow as to make them ineffective. Then, in the following years, we became acquainted with the fact that according to the Court of Justice, the exceptions and limitations we have in EU law have to be written in view of the fundamental rights that have been stated in the Charter of Fundamental Rights of the European Union, but also in view of the other constitutional principles of the European Union system. Then the outcome of this exercise has to be checked from the point of view of the three-steps test, which is, of course, meant to make the interpretation consistent with international obligations of the member states and also the European Union. The Court of Justice also pointed out, as I say, that the member states have a great amount of discretion in the implementation of the rules on exceptions and limitations that have not been fully harmonized. And this means that there's a great degree of diversity in the European Union in terms of the scope of the exceptions and so of the privileged use that can be performed without getting an authorization and sometimes without paying any kind of remuneration to the right holders. Then the Court of Justice also pointed out that the member states cannot introduce additional exceptions and limitations through laws, but also through direct application of the fundamental rights. This was a point stressed in three seminal decisions of the Court of Justice of the last year. Then the last point I think would be useful for our discussion is that under the European Union system, there might be other spaces of freedom that come from other principles of law, such as the implied consent, which has been recognized by the Court of Justice, but also through a narrow reading of exclusive rights. And this is the case in particular for the communication to the public right and also the making available online right. So be aware of the fact that there might be certain uses that do not fall within the list of exceptions and limitations, but at the same time are not covered by the by exclusive rights because of these other theories that apply. Next slide, please. So what about the COVID effects, if any? In my opinion, we should look at the issue taking two different points of views. One is the short-term view. And the question basically is, Should we be tolerant with facts occurred during the emergency or not? Should we apply somehow differently the exceptions and limitations because of the pandemic? But also we might want to take a long-term view and ask ourselves, if there is any take-home lesson that we should learn from the emergency and the problems that came with it in terms of the application of the exceptions and limitations. Next slide, please.
2 minutes.
2 minutes, very little. Short-term view, are we discussing a real problem? Maybe. My opinion is that it depends very much on the nature of the infringement, because to enforce certain rights against the uses that took place during the emergency can be extremely difficult, but also it depends on the attitude of the parties. I understand that copyright holders that would not run against the feelings of the people trying to enforce their rights while the people are suffering. Next slide, please. So here are some examples of uses that took place during the emergency. I don't have the time to discuss them, but trust me, there are certain examples that are easy to deal with because the exceptions and limitations that we do have under EU law might cover them. And there are more difficult cases that are cases in which the exceptions and limitations we have might not apply for one reason or the other. Okay? Next slide, please. Next. Sorry, the slide before. So, rushing to the conclusions, what happens if any of the exceptions and limitations do not cover the uses that took place during the pandemic? This is very unlikely, I think, because we can use the fundamental rights arguments that the Court of Justice allowed to cover these cases, also because we can take into account more fundamental rights than in the normal cases. Just to mention one of them, the healthcare, so the right to health of the people, which is also psychological health. But also, if we cannot find a solution using this balancing of right within the exceptions and limitations that are listed in the directive, we might think as a possible solution for the Court of Justice to allow a use of fundamental rights balancing exercises even outside the list of the exceptions and limitations. So allowing us to use them as an external limit to copyright protection. Then we might also want to rely on other principles of law. What could be these principles of law? Ordre public, for example, can be used probably to avoid the recognition of foreign judgments enforcing copyright in respect of acts that occurred during the pandemic. But also we might want to rely on other principles such as proportionality and abuse of right that can be used not to deny the existence of an infringement, but to deny the availability of certain remedies in view of the specific circumstances of the case. I don't have the time to explain you why and how, but again, there will be time for this. The last slide is about the long-term view. Basically, the idea is that the pandemic showed us that it would be much better to have an open-ended fair use clause even in the EU law to cover certain unexpected, unforeseen cases. Also, another point is that harmonization requires mandatory exceptions and limitations, requires a decision against freedom of the states, basically. Then, looking at the more recent legislation from the EU, we might say that the legislator has taken certain steps in the right direction. most notably in respect of uses taking place for academic purposes or for teaching online, where the legislator, departing from the traditional territoriality of copyright, decided to apply the principle of the country of origin to make use of works online much easier in the European Union. And also, the last point I would like to make is to take the opportunity of the implementation of the Copyright Digital Single Market Directive in the EU to modernize the entire system in the member states. So this is an opportunity for us, for nationals of the countries of the Union, to work a bit on the system of exceptions and limitations that was established in the early 2000s, when the major problem was, in our view, to secure protection for copyright holders in the online environment. Now the environment has changed quite much, so this is the right time to work on our laws. Thank you.
Thank you very much, Alessandro. Very interesting in both the short time and the long time perspective. We will actually head directly to the next slide and the next speaker, and that is Brian from Canada. So let's jump overseas to another part of the world. Please, Brian, you have to unmute you. No, great.
Okay, you can hear me now fine?
Yes, we can.
Okay.
So 10 minutes, Brian.
Thank you, Sanna.
Thank you.
And I want to go to the first slide, please. I'm not going to belabor this. I mean, Professor Cogo has already spoken about this. It's clear that the online environment in the time of pandemic has changed everything. Everything is now going to be virtually copied. Things that are live performances have to be transmitted and communicated to the public. Books that aren't available have to be copied or read aloud or transferred digitally. And so that, ironically, the pandemic has increased the importance of copyright. Next slide. Obviously, books that are no longer available have to be, they have to have a reproduction right. You have to have a right to communicate to the public. Things that are transmitted on the internet or transient copies are made. Most of the exceptions are for, at least in the Canadian context, in education, are for the physical use in a classroom on the premises of a school. So of course that disappears, and the exceptions now don't always apply or have to be stretched. So next slide. Copyright hasn't changed the letter of copyright law in Canada. I guess it probably hasn't changed the letter of the law anywhere. But like the United States and unlike Europe, apparently from Professor Cogo's comments, we do have an exception for fair dealing, and the exception is purposely meant to be flexible. And while fair dealing in Canada has traditionally been more restricted than fair use in the United States, nevertheless, the same factors, what I call the Section 107 factors in the U.S. Copyright Act, have been applied in more or less the same way by the Supreme Court of Canada in 2004. But the reason why Canada is traditionally thought to be more restricted is because, and I don't say this in the slide, but the only specific allowable purposes are covered by fair dealing, and those are rather broad now, but research, private study, education, criticism, and review, parody, satire, and news reporting. Now, since I'm only talking here about the use in education, that is an allowable purpose, so we can move right immediately to looking at the factors that would be involved in whether a use is fair or not. So let's go to the next slide. So in Canada, the uses, there are six factors. The US 107 factors, I think there are 4, but they align pretty closely. The first is the purpose of the dealing. And this is really the heart of the matter in many ways. The court has said that you need an objective assessment of the real purpose or motive behind the use of the copyrighted work. What's the real purpose of the required use? And the character of the dealing, here we're looking at the question of whether it's single or multiple uses, whether the work is to be kept for a while or destroyed immediately afterwards, to whom is to be distributed, and what is the normal course of dealing in the trade. The third factor, the amount of the dealing, is really the quantity of the dealing, and that's not, the court has said, is not determinative, although In the past, they've often used a 10% rule, but it's quite clear that in some cases, copying of the whole amount might still be fair dealing, although that traditionally has not been the case. Alternatives to the dealing, here the Supreme Court has surprisingly said that the availability of a license is not relevant. Seems to me that the availability of a reasonable license ought to be relevant, but the court here was concerned about vitiating the fair dealing exception if in fact a person could offer a license and then say that it's not fair dealing, when the person would, a user would ultimately be entitled to the fair dealing exception. If the fifth is the effect of the dealing on the work, and here the court has also been a little bit hard on copyright owners. They say that there must be demonstrable harm to the copyright owner, not just something speculative. And finally, the nature of the work, and here that's probably the least important, but the question of whether the work is published or not published, confidential or not published, not confidential. Perhaps also here would be, although that's not been traditionally also in the case law, a public interest exception, the nature of the work, for instance, if it was a medical treatise of some sort, for instance, relating to the COVID-19. So next slide, please. So I'm going to, in the interest of time, I'm going to go over this very quickly, but obviously there's a number of library associations who are, I would have to say, not completely unbiased in this matter, who have determined that in the pandemic, it would be fair use really to allow the access to books online. And so I'll skip next slide. And some Canadian academics have also adopted the American view that fair dealing factors favor the fair dealing exceptions for reproduction and communication of materials when classrooms are moved online. And some Canadian universities have even said that if it was okay to do it in a class, it's often okay to do online, especially when the access is limited to the same enrolled students. The U.S. copyright specialists have also made statements recommending that the fair use should apply, although they haven't gone so far as to suggest that you can break a technological protection measure. Next slide. In the U.S., major publishing houses have sued the nonprofit Internet Archives for first they provided unlimited access to books during the COVID-19 shutdown. Subsequently, after the lawsuit started, they abandoned that and moved to what they had done previously, which was called the controlled digital lending model. And they followed that. They've been following that model for a long time, since about the last 10 years. And under that model, the group allows only one patron to digitally check out a book for each physical copy the library has in stock. But however, that didn't satisfy the publishers. Once they got started, the last word is they haven't abandoned their lawsuit, and that they want to make it a test case for library exceptions under the Copyright Act. Next slide. As discussed, we do have broad exceptions, and just apparently like in the European Union, I was interested to hear Professor Cogo refer to these as user rights. Our court, perhaps maybe the first court in the world, in the KCH case in 2004, referred to these exceptions as user rights, and that certainly changed the mindset of the court in dealing with these exceptions of it, rather giving them a much more liberal interpretation. But fair dealing may not apply in all circumstances, and there are a number of specific detailed exceptions, and I'm dealing really mainly here in this short time with the educational use exceptions. And you can't, if you can't rely on fair dealing, you have to go thread your way through these specific exceptions. There are a couple of others that would apply in education, and one of them is user-generated rights, which we'll talk about. That's not restricted to education, and we'll talk about that in the next session. Next slide. So,
2 minutes.
2 minutes, okay. So one of the, what I went to do is, I guess I'm not a professor, and I think of things that maybe, it doesn't mean it. I ask myself, what are the people in the real world, what are they telling people about these exceptions during the pandemic? Well, I've got a reference there to the Council of Ministers of Education, which are the ministers of education in all the provinces in Canada. And they've put out a series of questions and answers about what students can and can't do, or what teachers rather can and can't do online. And so it's sort of, I think, interesting to see how they've applied the Canadian copyright rules in the current circumstances. I'm going to skip question 10 in the interest of time and go to the next slide, please. So this one question was, can teachers post online chapters of textbooks that have been purchased for all the students, but which may not be accessible to them because the books are in a closed school? So this, of course, is the issue of that has been raised by the Internet Archive. A teacher can post one copy, but here they've adopted the rather narrow restriction or interpretation of the fair dealing exceptions, saying that a teacher can post one chapter under the fair dealing guidelines, but they can't continue to post a new chapter every week to cover the whole book. They can only do a single copy. Next slide. Can a teacher read a story to students to promote in the evening on Facebook Live or a similar online platform to promote literacy? Now this is interesting because this section allows a teacher to read a story to students in a classroom, on the premises of a classroom for education and teaching. But the education ministers have interpreted that strictly too, that since there's no provision in the Copyright Act that would allow the activity to promote literacy and where it's not particularly in a classroom, even though it appears to be the question stipulates that it's a reading to students. So they've said, no, you can't do this, but turn to the next slide, please. But when it's a live book reading by a teacher online and they've assumed in the context of an educational context of a class, well then section 29.5 applies and that's allowed. You're reading it to students in a classroom for not-for-profit, and that falls under the exception of section 29.5. But you can see there's a narrow distinction between whether it's you're reading it for educational purposes in a classroom or whether you're reading it for promote literacy. It's a very narrow distinction in both cases, and one could argue they're educational, but not. Next slide, please. Can teachers transmit a recording of the book reading to their students via a password-protected site? Well, this is interesting too, because although there's a section in the Copyright Act that allows the communication of the lesson to students, only if the recording of the book reading is authorized. And of course, in the context of this, the recording is not authorized. So even though the section allows the online, if you will, remote teaching of a lesson, it actually is still restricted because the book copying has not been, the book reading itself has not been authorized. Next slide, please. So this is perhaps one of the other interesting things about Canadian law, which was amended in 2012. Although a teacher can't read the work for him or herself, as we just see online, if you can find and in fact the Council of Ministers suggests this, if you can find someone else reading it on YouTube, you can use it. So it's an ironic, in my mind anyway, it's a little ironic that a teacher can't read the work of him or herself online for educational purposes. If they can find it on YouTube, they can read it, they can use it because of the exception that allows an educational institution to use anything. The educational institution can use anything that is posted on the internet as long as it's not protected by a technological protection measure and there's no clearly visible notice prohibiting the use. And the section specifically says that a copyright symbol is not a sufficient notice. So some commentators have argued that this broad exception is in violation of the three-step tests mandated by Byrne. And that concludes my talk on this part of the panel. I hope I'm in time.
Thank you very much, Brian. That was very interesting. Now we will start to move on this fantastic planet, and we will go to China. So soon we have a circle. Please, Nathan, let us know what the exceptional limitations are in China and during this time.
Okay, thanks, Sanna. Actually, it's finally my turn, and I found most of the content I prepared have been covered by Professor Cogo and Ray. So, but at least I'll be slower. So. Okay, in Chinese copyright law, we have actually two groups of exemptions. One is fair use, the other is statutory license. And people talks about compulsory license a lot. We don't have it yet in our law, but I may talk a little bit about it if there is still time in a later part. The next slide, please. Our law has listed 12 specific situations for fair use. Next slide. And 5 additional situations for statutory license. Next slide. But I'm not gonna go through them one by one. Instead, I'd like to discuss them in the background of 3 scenarios during the pandemic. The first is about teaching. As the speakers have repeatedly emphasized that teaching is not well exempted if a teacher is giving class online. Next slide. In China, there was a change in the history. Before 2006, teaching exemptions like in our law, we have teaching fair use, and we have an additional clause about education statutory lessons. Before 2006, those teaching exemptions didn't apply to online classes. But in 2006, we have an administrative regulation released by the government that was focusing on copyright and the internet. And that regulation expanded teaching fair use and education statutory lessons to the internet context. So after that, teachers can be exempted, can rely on fair use and statutory lessons when they are giving online classes. But they are still less safe in online classes than they were in face-to-face classes. One reason is that the 2006 regulation does not apply to unrepeatable live streaming, which means when the teacher is live streaming his class on the internet, he cannot claim for the fair use defense. So I don't think the legislature means to do that. It's just something they forgot to cover, I think so. But it's a problem. And another problem is about situations like when teacher, they are giving classes in face-to-face classes, they can read a book to the students and it will not infringe anybody's copyright, right? But if they are in an online class and they read a book to the students, it might constitute copyright infringement depending on the amount of the book he will read. So next slide, please. So we can see that our copyright law doesn't really prepare for the situation like COVID-19, like the pandemic. And the next I'd like to discuss is about news spread. These shorts are from one of my favorite movies, and it's my favorite part of it. The part tells a story that the patients have some special medical needs, but they can't get help from the public services. So they pass on information through the internet and help each other. So this is really important during emergent situations like the COVID-19 pandemic, especially when the public service provider don't do a very good job. So people should rely on the flow of information to help themselves. But if you have some information like a news article about the virus and you want to transfer it to your friend or your followers on social media, is it safe or not? Next slide. In Chinese copyright law, the answer will be probably no. We have 3 exemptions concerning news reporting, and all of them are exclusive for licensed reporters. And if we look deeper into the clauses, we will find that the only one among the 3 applicable to online communication is the republishing fair use. The other 2 don't apply to online environment. And the republishing fair use is limited to political and economical topics when it comes to online. So actually, if you are a licensed reporter, you cannot transfer a news article about the vaccine to another friend or followers. Even you may be able to do that in an offline environment. So next slide. And the third scenario is about libraries, archives, and museums. And I will not play this video because of the time limit. So
you have the time, Nathan, to do it. So please play the video.
Okay, okay, thank you. No, I can't do that because I need to open it in my own slide. I didn't open it. So let's just skip it. We have 2 more videos on a later stage. So
okay,
we have
thank
enough
you.
videos to watch. Okay, next slide. So nowadays, a lot of museums and libraries are transforming to online. But can they do that without any risk of copyright infringement? Actually, under Chinese copyright law, library, archives, and museums do have fair use for them. But that fair use is limited to making hard copies. And the 2006 regulation we talked about expanded such fair use to online environment, but only to the extent of providing digitalized copies to people when the people are staying on their premises. So if they want to enable the audience to watch an exhibition from home, they cannot do that without permission from the copyright owner. So next slide, please. So from the 3 scenarios, we can see that copyright law doesn't really get prepared for the COVID-19. But is there any solution? There probably is. One solution is about judicial practices, because lately Chinese courts have developed some case law, and the courts tend to be more flexible and give a broader interpretation about fair use. One example is a 2015 case. The court, for the first time in China, adopted a theory of transformative use. That theory may play a very important role in the cases involving user-generated content that we will discuss later. And another bolder breakthrough was in 2017. A court asked the question that we are in an age of new technology. So why we should be bound by the specific situations designed decades before? The current copyright law of China was enacted like before even smartphone came out. So that is the question the court asked. And the court's own answer was, no, we shouldn't. So the court replaced the traditional 3 steps test with a 2 steps test. That is, if the use didn't affect the normal use of the copyrighted work and didn't cause unreasonable harm to the copyright owner, that should be a fair use. So that new rule has a brighter future to accommodate copyright law with the people's needs during pandemic. Because it's fair enough to say that some harm has to be caused when the public interest weigh out the benefit of the copyright owners. So we will see whether the case law will go further in the future. Actually, China is amending its copyright law currently, and the current draft of the amendment has added an open-ended clause that other situations may also be determined as fair use, other than those expressly listed in the current copyright law. But in my personal view, I think the ultimate solution may be to adopt the theory of compulsory license. Because if we rely on the judges to interpret fair use more flexibly or give a broader interpretation, we will lose consistency or foreseeability. So we finally need a clause about compulsory license that in emergencies, people can go to the government and say, we need that license. If the copyright owner don't grant the license, the government should do that. Okay, thanks.
Thank you very much, Nathan, and also Brian and Alessandro. And now the first part is we have the framework, the copyright, the legal framework, and let's have some discussion. I would first like to ask, I have some questions also on the Q&A, but I would also first ask the panel, what do you think? Because I always have thought that compulsory license are an interesting concept. So Brian and Alessandro, have you thought about it? Please unmute you when you're talking.
Well, we have no compulsory licensing for copyright. We have gone through a very different system. I mean, we have collective societies and tariffs set by the collective societies, and in that sense, it's a kind of group licensing. Whether you would call it compulsory or not, but certainly that's the system that we have adopted. Generally, I would say that the theory of a forced compulsory license is something that would not be particularly welcome in Canada. We've generally followed the North American model of not doing that. We've had that in patents and it was eliminated. Anyway, I think the way we would do it would be through some sort of collective society where tariffs were set and the works were licensed in a group according to a tariff. We have 16 collective societies in Canada for everything under the sun, so it's we're very active in that area.
What I think about compulsory licenses in the copyright field, I might say this is rather unusual. We know compulsory licenses as a tool that can be used in the patent law field, and also you can find rules allowing for compulsory licenses in the patent field. Look at TRIPS, trade-related aspects of intellectual property, Article 30, if I'm not mistaken, and then you find a rule saying that the states can apply compulsory licenses in that field. We don't have anything similar in the conventions and also the TRIPS, while they deal with copyright protection, which doesn't mean by itself that it would be not compatible with international obligations, but still still, this is one of the questions that need to be solved in that connection. Then looking at the substance of the problem, I might say that we are basically, if I understand Nathan's point rightly, we are basically discussing whether should be the judge to allow a certain use while at the same time requiring the person using the work to pay some monies to the right holders, or whether we should have a public body other than the judiciary granting licenses, even if the right holders are not, you know, do not agree with the license, where the difference is also that here you have to ask for a permission first and then you use the work, while on the other hand, if we rely on the judiciary, you first use normally and then the judge might grant you something similar to an ex post license, maybe asking you to pay monies, as I said. I'm not sure whether it would make sense to entrust a public body to issue compulsory licenses, also considering that we don't have anything similar to an intellectual property office, as a patent office or a trademark office that can be entrusted with that function, at least in the European Union and also in all the countries that apply the rule that copyright protection is available automatically in a very strict sense. So we would have to establish a new public body just for the sake of administering these compulsory licenses. I personally don't like the idea of having a public body other than the judiciary with the discretionary power to grant licenses against the will of right holders. In any conceivable case, the public body deems fit. So I don't think this is honestly a good solution against the issue of legal certainty, lack of legal certainty, because if the compulsory license can be granted for any reason, then again, you will have the same uncertainty and also the problem that the system would not be administered by the judiciary with all the guarantees that are connected with it. So I'm skeptical, actually.
Thank you. I don't think we ever have 100% certainty in law. Otherwise, we could skip the lawyers. That's very interesting about the different views on compulsory licensing. I have just a short, we have to move on actually, so I will take that later. And let's talk about the user-generated content, because we had a question also about fair use, and I think that's also quite good to have it after we heard about the user-generated content. And first we'll start within the European Union with the next slide, please, with Alessandro, who will start. And now we have a shorter, this is a bit shorter, so it's maximum 5 minutes each speaker.
Okay, very short. Again, it's like a speed date. You don't have to.
Yeah, I know. We love speed dating, you know. Italian, you know.
So I'll be very brief. As you know, we don't, well, you don't know because I didn't have the time to explain it before, but we don't have a specific exemption for the user-generated contents in European Union law. General exceptions and limitations might apply also to UGCs, such as, for instance, the quotation exemption or the parody exemption or the pastiche exemption, just to name a few. Problem is, as I said, that these are all optional exceptions, and so they might apply in certain European Union countries, while they might not apply in other countries, or they might apply in a different manner. So for us Europeans, this is a real issue because we lack legal certainty. So this might have a chilling effect if you have people that want to post content online while respecting the laws of any countries, at least in the EU. So the new directive that I already mentioned, the Copyright in the Digital Single Market Directive last year, somehow reinforces the protection of exceptions and limitations that are mostly used to share content online. So the quotation, criticism, review, caricature, parody, pastiche, exceptions and limitations now are specifically listed in the pool, Article 17, that is meant to deal with the online content sharing platforms. Then there's another rule in the same article of the new directive, which basically says that the licenses that the online platforms have to get from the right holders according to this new system will also cover the sharing of user-generated contents performed by people acting for non-commercial purposes and not making relevant income from the sharing of content online on the platforms. Next slide, please. A few comments of mine. As I say, the application of the general exceptions and limitation is problematic. The new directive has not yet been implemented by many member states, almost all the member states. And so we don't have a rule, a system already in place that can be used and relied upon for the pandemic. We know at the same time that the new directive somehow prompts dialogues between the right holders and the content sharing platforms providers. And we know that have started negotiating the kind of licenses that are imposed by the new directive. So it might be that the right holders do not have the incentives to act against the online sharing that increased during the pandemic, also for this reason. Looking at the new system that will be put in place by the directive, I might say, as many said before me, that the system is very complicated, and also that the provisions that should be that are meant to help sharing online of user-generated contents are rather unclear. So, as I said, the directive says that that certain exceptions and limitations.
Hej David, jag sitter i möte. Jag kommer hem om en timme. Hej.
Sanna, I think you are unmuted.
Sorry.
No problem at all.
Thank you very much, Alessandro. This is very interesting. And we will now jump over to, again, the sea, to Canada, and have the Canadian perspective with Brian. Brian, you have to unmute. Brian.
You can hear me now?
Yes.
Okay. Thank you, Sanna. So let's go to the first slide, the next slide. So I've alluded to this already. Oh no, sorry, go back one slide. I've alluded to this already, that in 2012, we had a significant year in copyright law. It was a dramatic overhaul of our Copyright Act, and that occurred simultaneously with 5 Supreme Court of Canada decisions that came to be known as the Copyright Pentalogy. And these decisions, first of all, they introduced a further liberalization of the idea of user rights. But the 2012 amendments also introduced a number of exceptions for activities done by individuals for their personal non-commercial use. And that included the inclusion in a non-commercial user-generated content, which we're going to talk about, but it also included the reproduction of a work that had been legally obtained for private purposes. It included time shifting, the making of backup copies, as long as no TPM is circumvented. And these exceptions were not restricted to education. Next slide. So we have a specific exemption for user-generated content, and it's very interesting. And I think we can spend a lot of time analyzing this rather complex section to understand what it means. So I'm just going to read it to you and highlight certain parts. You see that says that it's not an infringement of copyright to use an existing work or other subject matter. So I stop right there because it says use an existing work or other subject matter. So one wonders what it is that wouldn't be a work that you could use. But obviously it was intended to be very broad to allow you to use anything or a copy of one which has been published or otherwise made available to the public in the creation of a new work or other subject matter in which copyright subsists. And this is interesting too, and for the individual or with the individual's authorization or a member of their household to use the new work or other subject matter or to authorize an intermediary to disseminate it. So another interesting aspect of it is the right to use a published work or something that is otherwise made available to the public. So again, they don't want to restrict it to specifically the detailed understanding of what published is if it is made available to the public. And also it very specifically allows you to disseminate this work to an intermediary. An intermediary is defined as a person or entity who regularly provides space or means of or for works or other material to be enjoyed by the public. Next slide, please. So the conditions of using these user-generated rights are if the use or authorization to disseminate is solely for non-commercial purposes, the source is mentioned if it's reasonable to do so, the individual has reasonable grounds to believe that the existing subject matter was not infringing copyright, and the use or authorization to disseminate the new work does not have and here again, other untested things not defined. The use of the work does not have a substantial adverse effect, undefined, financial or otherwise, on the exploitation or a potential exploitation of the existing work or other subject matter of an existing or potential market for the existing work, including that the new work is not a substitute for the existing one. And as I said, this is sometimes called the YouTube exemption. Now, a search yesterday for cases under this section found only one in which the exemption was not allowed because it dealt with a unpublished work. But other than that, there's been no, it's typical of Canada. We're not the United States. We don't have a lot of litigation. So surprisingly enough, there is really no litigation to help us understand what this section means. Can you have the next slide, please? As you can see, the exemption is very open-ended. What makes a work new? So you can use any copyrighted work in the making of a new work. What makes a work new? Does it have to be original to be new? Does it have to have the level of originality that arises for copyright protection? How much of the existing work can be used? Can you take the whole of a Beatles White Album or somebody else's album and run it alongside your wedding video? Apparently, yes. So the implications for educational uses can be seen by the Council of Education Ministers' answers. And I just want to deal with that one question or one answer. So next slide. Can the teachers include modern day music in a video that teachers are preparing for their students? And the answer is, you'll see very broadly, yes, everyone, instructors and students include, has a right under the Copyright Act to use and enjoy and copy a copyright protected work or multiple works in the creation of a new work. This right allows, for example, the use of copyright protected music to accompany an original video. It allows anyone to compile multiple videos in a creative fashion to create a new video. This right further allows a person to disseminate the work. Dissemination is a broad term and would include, for example, posting the user-generated content on the internet and using many popular television shows, movies, and music are posted on YouTube with copyright permission. And then they go on to say this right allows YouTube users to make videos containing clips from television shows, movies, and popular music found legally on YouTube. The scope of the right, however, is not limited to content found on the YouTube. So you see that it really is interpreted very broadly too by the ministers. So although a teacher, as I said earlier, may not read a story over the internet to students, or at least not record it, they can't record the story, or then they can't read the story for non-educational uses in a classroom. Presumably they could read the story to music, and reading the story to music, maybe that creates a new work, and they can do that, interestingly enough. So is it right too broad? Does it conflict with the three-step test? Many rights holders do think so. There's a lot of discussion when this section was put in 2012. And thank you, that's the end of my presentation.
Thank you very much, Brian. And now we jump over another water to China and the last part. And after that, we will have discussion both on user-generated content and also some other questions. Please, Nathan.
Okay, the next slide, please. The first slide is just some statistics to show that UGC-related businesses and topics are very important in China currently. Next slide. Despite of that, I have to say that Chinese legislation hasn't kept pace with EU or Canada in this area. But we have some cases. The latest developments in China center around two pioneer cases. The first one is about short videos that you can see on apps like TikTok. Typically, short videos are created by unprofessional users of the apps, and they are usually mashups of existing copyrighted works of others. Their background music may come from a pop song, or the character or setting maybe from a Hollywood movie, something like that. In the first case we're going to talk about, the court was requested to decide whether a short video should be protected as a quasi-movie or as a videography. Because under Chinese copyright law, a quasi-movie is a kind of work eligible for copyright protection, while videography work isn't. Instead, videography is under a lower level protection by related rights. So that's why the distinction matters. And it depends on level of originality, which side it should belong to. A video cannot be treated as a quasi-movie unless it has enough originality. With that in mind, you can look at this short video yourself and make your own judgment. Next slide. And I can play video. Anybody look forward to my video? Okay. So the song and the main part of the dance was actually created by a Japanese artist, the gentleman, this gentleman. This guy is just trying to imitate that artist in this video. And he added some fruits and some visual effects. But it's not very complicated. I think we all can do it or something similar. So is such a video eligible for copyright protection? Or do you think it has enough originality? In that case, the court said that such a video already has enough originality because of the new additions, designs, and the choices the creator have made. So this is the first time in China that a short video is categorized as a quasi-movie and has been recognized eligible for copyright protection. The second pioneer case was about online game live streaming. So again, let's look at this video first. So in this case, the game live streaming platform was sued by the game developer. The game developer argued that in addition to the underlying game, what people see on the screen, the whole moving pictures when the player is playing the game is also covered by by their copyright. That's the developer's argument. But as you can see, these consecutive pictures were actually generated in the course of interactions between the computer and the user. It is the user who controls the movement in the game, and that affects what the picture will look like and what direction the game will go. Okay, let's go back to our slides. So, however, the court in that case was audacious enough to support the plaintiff's argument. Okay, let's go back to our slides. Thank you. And the court, for the first time, recognized that user-generated game live streaming pictures belong to a kind of quasi-movie and eligible for copyright protection. So this judgment seems to be too progressive, and it actually arose many discussions. But at least I think we don't have much legislation, but we have some cases. And we can see for UGC, there will still be a lot of debates in China, and we have a long way for us to go. Thanks, everybody, for your listening.
Thank you very much, Nathan, and also again, Brian and Alessandro. Very interesting, this with user-generated content, and especially with all the YouTubers who are doing the video games and other their tricks and tips. We had first a question, a general question, and this is actually connected to if something is not over a copyrighted work, for example, an article is not yet published, it's not made available to the public. But for example, if this article, a scientist have the conclusion to COVID vaccine or something, but he gives that article to a company first and don't make it available to the public. Should that be something, if somebody get a hand on it and put it to the public? Is that a copyright infringement in, for example, in China or in Canada? For sure in Europe, I would say.
Well, one of the fair use factors clearly is the question of whether it's published or unpublished. So an unpublished work, I would say that the court would be very reluctant to consider that to be fair dealing, to publish an unpublished work. It's still possible, I suppose, if there is a overriding public interest, but I would suspect that it wouldn't be fair dealing. Of course, obviously not a copyright issue, but publishing something that's confidential has other implications too for breach of confidentiality. But I think it probably wouldn't be fair dealing. But of course, you need to understand all the circumstances. Court has said in CCH that you need to consider all the factors together, giving them full treatment, considering all of them, not treating one factor as predominant over all the others. So.
Thank you, Brian. We also have this other aspect that we have quite strong in the European Union is the fundamental rights, that we can balance it. But I'm not really sure when something is not made available to the public or unpublished material. What do you think, Alessandro?
Well, generally, exceptions and limitations apply to published works, also because we have an implication in terms of the protection of moral rights, personality of the author. Okay? So the idea here is that if a work has not been published, then for the author is not ready to be published somehow. So it is true that we are talking about economic rights and this connection, but we also know that economic rights are meant to protect also the personality of the author. Okay? So this might be a problem. Also, we have some indications regarding the issue and the decision of the Court of Justice in the case Funke Medien of last year, which might be of interest for our friend that posed the question to us. And there you see that the problem in the end does not arise when you have the idea of publishing information that is contained in a copyrighted work without making use of the copyright work itself. So in these kind of situations, then the issue might be also one of proportionality. If you could publish the information without using the specific words, and so the article that you have in your hands, why haven't you done so? So this might be a factor that might turn the balance against the user.
Thank you, Alessandro. And what do you think, Nathan, from a Chinese perspective on unpublished material, and that it's really important for the rest of the world?
Yeah, according to Chinese copyright law, all exemptions, whether it's fair use or statutory license, are only applicable to published work. So I don't think there is any room, no matter how brave the court will be, to interpret it into the basket of fair use or statutory license. However, as an attorney, I tend to consider questions from the perspective of practice. Practically speaking, if you have an unpublished work and it was stolen by someone else, maybe it's more difficult for you to enforce your right, because it's really hard to find evidence about your authorship. And it's a big problem in China, where often when people go to the court, the plaintiffs find it very difficult to prove he had created the work. And that's why we need the copyright registration. But if you are planning to finish the work and you are finalizing the work, but you haven't do copyright registration, maybe practically speaking, someone stealing your work will be will get away from legal liability because of lack of evidence.
And hopefully the courts are balanced and actually have very low or null damages in such a case, even if it's a copyright infringement. We always have that aspect.
Yeah, we had a case in Canada. You know, we have free speech rights and rights of free expression, freedom of expression. And there was a case in Canada involving a labor union that wanted to use, you know, the Michelin Man, the big babendum, the big stuffy guy that's made out of tires. And they had that in a Michelin strike literature. They had the Michelin Man was stomping on a worker, and they argued that they had a free speech, freedom of expression right to copy the babendum and use that in this anti-company literature for promotion of the strike. And the court dismissed that. They said that the free speech and freedom of expression, which is constitutionally protected, does not allow you to use a copyright protected work in that context.
Thank you. It actually struck me that we have one limitation in the InfoSoc directive that actually goes for unpublished material. Also, it's a small opening, and that's when newspaper are publishing. So we have a small one in the InfoSoc directive on the European, but that's for newspapers, even for unpublished material, actually. It's just hit me now. We have a question here from Ben, and he asks you, does you see that any of these limitations and exceptions we have, would they, after the pandemic, will they even perhaps expand, that we need to expand them in some kind of way, some special of this limitation and the exceptions that we have, that we will have for the future? We don't unmute you, Alessandro.
No, just to be sure, are you asking us about the
post-corona
the interpretation of existing limitations?
No, more to actually change them.
Well, if I should start, from the European Union perspective, we already know that we can rely on fundamental rights for the interpretation of these existing exceptions and limitations. This is rather new for us, I would say. Yeah. And so I think we have a great deal of room for improvement if we want to find additional freedom in the copyright system. So it's about testing the full reach of the fundamental rights argument in the field of exceptions and limitations. So this is somehow a field that will be explored in the coming years. I expect it to be so. So I expect to see an increase in the degree of freedom that we have in Europe. Regarding potential reforms in the law, I think that we already have, as I said, something new in place, and the new copyright directive. And so again, we will see how much freedom we can get from that directive. In my last slide about the UGCs, the last point I made, I didn't have the time to do it properly, was that the new rule of Article 17.7, subsection 7, which mentions the quotation, criticism, parody, and other exceptions and limitations, can be seen as a rule providing full harmonization of these exceptions and limitations, and not just the mandatory application against the right holders and the platforms while dealing with the licenses for use on platforms. Which, if this is the case, we will see in the coming years the Court of Justice putting meaning into a provision which says very little. It just mentions quotation, it mentions pastiche, it mentions criticism, but it doesn't say a word about the exact meaning of these exceptions. So if this reading will make its way in the jurisprudence of the Court of Justice, we will see a lot of fundamental rights balancing exercises performed by the Court of Justice, a lot of it, with, I would say, unpredictable results, actually.
Yeah, so no, it's very, very interesting. So what will happen with the copyright system after, because we really put it on the edge with all our very, very limited and close limitations in the European Union. We don't have this possibility with the fair use. And as been mentioned before, I think that a fair use doctrine will actually enter into more legislations now after this, especially to have the cultural sector running. Nathan, do you have any thoughts about this? Otherwise, I also have another question here. But first, Nathan, if you have any thoughts about this.
Yeah, in China, actually, during the outbreak of the virus, just all the cities have the lockdown measures. So nobody go to the court, even the judges. Mm-hmm. So we don't have some real case to adapt to the changes during the pandemic. But I personally think we have one more defense for copyrighted materials users. For example, during the pandemic, many local governments has released a lot of regulations and some temporary orders. And those orders may be related to some change of usage of copyrighted works. For example, the education local authority may instruct all the schools to move the teaching onto the internet. With that regulation, the users may have of fair use defense or other defense that I'm using the copyrighted materials, that should be infringing according to the law, but we have a special situation and the government, local government has said that. So that may be an additional defense. And also China is amending its copyright law, as I said. So it's very possible that China will add an open-ended clause into the fair use clause when the law is published. Then we have more room to interpret what is fair or what is not fair. So that's all. Thank you.
Thank you. I think it's going to be a really, really interesting development after this, not just in the copyright field, in all IP fields. We have another question from Moderator to Ben. You said that the teacher can use YouTube videos while teaching the student. Can the teacher upload the same lecture on YouTube as the same will involve some commercial? Yeah, could the teacher put this also on YouTube, the same lecture that he used the film under the licenses you have in Canada?
The teacher is using the YouTube video while teaching the student. Obviously, it's found on the internet, so they're clearly they can do it.
Yeah, and then he's filmed when he's doing it. Can he put it up on YouTube? His film?
They can't. It has to be for non-commercial purposes, so they can't upload the video on the YouTube if it would involve a commercial transaction. So it has to be for non-commercial purposes. So they can take the YouTube video, which while they're teaching the students, and if they take if they have taken it from the YouTube, it's freely available on the internet. Yes, they can upload it for the lecture, but not for the purposes of a commercial transaction. I'm not sure what it means. It will involve some. I don't see it as involving a commercial transaction. Simply uploading the YouTube video for the purposes of teaching.
Yeah, because if somebody's filming you when you're teaching, because at the universities and the lower schools and everything, you have, in most countries, you have licenses or exemptions that you can use copyrighted material. But if somebody's filming you and you see that's in the background, then we have very different national legislation in this field, as I understand.
So you're saying that someone's filming you and there's a YouTube video in the background, or you're...
Yeah, that you downloaded from the internet, because in most countries you can do that by the...
Well, you've mashed it up, then you've created a mashup, you see, or you've created, because you created two works, the recorded video of you and the YouTube video that you've downloaded. That is exactly what is allowed, this sort of mashup, as you will, if you've created a new work. I mean, there's a question, I guess, that whether something is a new work for which copyright attaches. I listened to Nathan's talk with some interest, because I think there may be a question in Canada too, when you just simply put two things together which don't create, in a sense, a new work for which copyright attaches. So whether that would be exempted. But generally speaking, the threshold for copyright protection is so low that as soon as you do a mashup, in other words, you add two things together, such as playing music in connection with a lecture, I think you have created a new work. The standard of originality, or level of originality, is so low. So I think the bottom line is, yes, you would be able to do that, as long as it's not doing it for commercial purposes.
Thank you, Brian. Our session is soon ending, but before, I would like to have one final word for Nathan, Brian, and Alessandro. And that's my question to you. What's your takeaway for copyright and COVID? And it can be whatever you feel. So what's your takeaway on the subject copyright and COVID? We can start with Alessandro.
I'm not going to thank you for that. It's a difficult question. Well, to put it shortly, you might have noticed that, in my opinion, we Europeans are basically looking nowadays for flexibility within the system. Our system is rather complicated because there's this interplay of European Union law and member states law. And out of this interplay, a lot of constraints come to address unforeseen cases and to address the public interest or interests that are going in the opposite direction in comparison to that of the right holders. So my takeaway is that, as I said, we might need an open-ended clause in the European Union law to deal with cases such as this one. First thing. Second thing, we have to get used to arguments such as the fundamental rights arguments that are difficult to handle and that lead to a certain amount of legal uncertainty. The third point is that flexibility might come not just from exceptions and limitations, but also in other ways. One that I mentioned that I find really interesting is that of working on remedies. So not all the remedies might be available at all times. And this is already allowed by the existing framework.
I have to stop you because we only have 4 minutes left. I said one takeaway. Italian never listening. Nathan, what do you think?
Actually, I have learned a lot from these discussions because apparently EU and Canada have made a lot of contributions to this topic from their legislation and also the scholarships discussions. So I think for China, we should have more discussions on this, but unfortunately, the discussions in China are not insufficient. So from today's discussions, we can borrow some excellent ideas from Canada and EU, and some very good sparks in their thoughts. And another thing I think is that every speaker is emphasizing that we should add open-ended clause in fair use clause. So I'm just curious why it was not so at the very beginning. I think it was because the law were pro copyright owners. And in such a situation, the pandemic, the lockdowns, we should have a second thought because sometimes it is not always right to pro copyright owners. That's all.
Thank you, Nathan. And Brian, what is your one takeaway? Short one.
Well, one takeaway is that I think we amended our laws in 2012, and generally speaking, we have modernized in a way which I think has adapted to this online environment reasonably well. I think the one area where we would look at it is how much it's tied to the physical presence, for instance, in the classroom, where things are almost, maybe in the future, almost always will be in part not in any physical location. So I think we could perhaps look at some modernization there. But generally speaking, I think we've probably gone as far as the Canadian public and copyright owners are prepared to do at the moment with our 2012 amendments, and we'll be digesting them for the next little while to see how they work out.
Thank you, Brian. And I also have one takeaway, and I think that we should have in the like actually what IPPI is working for, that we actually should have a global simple harmonization of copyright. That's my takeaway of this session. It was very, very interesting. And thank you, the audience, and for all the questions, and also the panelists, Brian, Alessandro, and Nathan. And if this is recorded, so you can find it on the IPPI platform. And I think also as well the slides. Thank you for today, all of you.
Thanks.
Happy copyright.
Bye.
Bye-bye.
Bye.